I see that Mr. Kelsky has joined the call, or at least his video is up now, so I can confirm that the two attorneys, one for each side, are present. Before we begin, I'll check with Susie in the courtroom. Are we ready to proceed with the proceedings at this time?
Yes, we have court reporter and clerk present and one participant out in the audience.
Thank you. So court is now in session. We'll begin with the transcription of these proceedings. This is the case of the Department of Labor and Industries for the state of Washington versus Spiffy, Inc., doing business as Spiffy's Restaurant and Bakery. I am in charge of unmuting. So first, for the state, I'll unmute Mr. Du so he can introduce himself.
Good afternoon, Your Honor. Brian Du on behalf of the Department of Labor and Industries.
Thank you. And now I'll unmute Mr. Kelsky. You can introduce yourself.
Thank you, Your Honor. Jason Selsky on behalf of Spiffy Restaurant and Bakery.
Thank you. So again, I'm Judge Chris Lanise. This is the second court hearing in this case. As I explained previously, I am a elected Thurston County Superior Court judge, sitting by designation as a visiting judge for Lewis County Superior Court due to the recusals of the bench in that jurisdiction. I think the cleanest way, again, to address any requests by the media to record either by still image or video these proceedings is simply to ask again, does anyone have any objection to anyone recording these proceedings by WebEx, either by a still image or by video?
No, thank you, Your Honor.
Okay, so people who are participating by video or by WebEx right now do have permission without specifically requesting it to record these proceedings. I will remind everyone again, although we are conducting this hearing by WebEx, you all as participants in this hearing are expected to conduct yourself as if you were in the courtroom with the same professionalism and respect as we would expect you to have in the courtroom. Just because we're doing this through alternative distance means at this time does not mean that the expectation is any lessened. And so with that being said, this right now is a continuation of a prior hearing on an order to show cause regarding a temporary restraining order. Before we begin, I will inquire of the parties if they have any preliminary matters they'd like to address. First, Mr. Du, anything you'd like to address? And you're, okay, I'm gonna you may keep yourself unmuted, both of you, just so we don't have to keep unmuting you. So, Mr. Du, any requests?
No, thank you.
Thank you. Mr. Selsky, any requests?
No, Your Honor.
Thank you. And so I'll lay out a bit of background before we proceed at this time. This comes before the court for a hearing to determine whether or not the temporary restraining order previously issued by this court will remain in full force and effect pending a hearing on a preliminary injunction to be set at some point in the future. As a reminder, at this time, the only order of the court refers solely to the location where food may be consumed. This does not prohibit Spiffy's from being open, from employing individuals, from accepting orders for food, for preparing that food, or from having their loyal customers show up in your restaurant to get that food to dine elsewhere. The only thing that is prohibited by my order is for all those things to occur and for a customer, upon receiving their food, to stay in the geographic location or the confines of the inside of that restaurant to then consume that food. That is the sole issue that is present in my order, and that is what we will be discussing today. Again, the geographic location where customers may consume food acquired from Spiffy's. With that being said, I'm going to hear from Mr. Du first. You may proceed.
Thank you, Your Honor. I think most succinctly, as the declaration of Dr. Lindquist, the state epidemiologist, in paragraph 14 notes, quote, the most recent outbreak report released on December 10th, 2020 shows that the most common outbreak scenario reported is in restaurants and food service settings. Exposures and transmissions are most easily accomplished in these settings because people are within 6 feet of each other for extended periods without a mask while eating or drinking, unquote. Underlying his declaration are scientific studies from Texas A&M, Stanford University, Northwestern University, and a detailed examination of droplet transmission in a restaurant setting in Korea. Dr. Lindquist also pointed out at the time of his declaration that the weekly case counts in Lewis County had increased dramatically from 26 new cases for the week ending November 14th to 262 new cases for the week ending December 12th, 2020. Spiffy's has failed to offer any evidence to the contrary, so for our purposes, it is undisputed that the provision of indoor dine-in services at Spiffy's leads to a substantial probability that death or serious physical harm could result to any employee immediately or before the imminence of such danger can be eliminated through the enforcement procedures otherwise provided by RCW 4917. Thank you.
Thank you, Mr. Dew. Mr. Selsky, you may proceed. Are you muted again? Okay, I will unmute you, and now you may unmute yourself.
Thank you, Your Honor. And this motion really kind of pigtails off of the hearing that we had earlier, 1:30 with Farm Boy. Essentially, our arguments are going to be the same in both of these instances. The Department of Labor and Industries has a couple of missions, and one of them is to keep Washington safe and working. And quite frankly, in this case, what we're failing to see is the relationship between a dine-in setting and the death and severe consequences that it may happen or occur to an employee. What we do have in this case is we have numerous individuals, employees, and patrons of Spiffy's alike who have indicated that this restaurant is extremely clean. They sanitize all the time, masks are worn. This is no different than, absolutely none, than going into a McDonald's, than going into an airplane and sitting for 3 hours and consuming snacks and beverages. I would suggest that's probably even less healthy than a restaurant for an hour or so. In any case, Your Honor, our employees have these waivers, and we are doing everything possible to maintain social distancing, mask wearing, and compliance with the phase that we were previously in. What we have is the Department of L&I exercising these powers, which essentially they are saying, we want these employees to stay safe. That is our job. We think that there's an imminent fear of grave harm or deadly injury. However, what we do see is there's no tie-in to an actual sit-down restaurant. There's restaurants like McDonald's, there's grocery stores such as Costco, and we don't think that there is any relationship whatsoever except for the unilateral decision of the governor to include a dine-in restaurant in his proclamation and in this temporary restraining order. We do understand that the governor just now announced that everyone now is again in phase one for at least a 2-week period. So any deference that Your Honor gives to this or any review hearing you may wish, we would ask again that this be set for a 2-week period to analyze everything is going in this case and where the state is headed in this, I guess, these new phases that you just announced about 10 minutes ago. And if Your Honor has any questions, I would be more than willing to answer.
Thank you. No, I will note that the court is also aware, this is not part of the record, but I think we're all aware that the governor did just have a press conference where my understanding is that there were certain goalposts, let's say, that were identified to allow certain things to happen at some point in the future, but not yet, which would include once a different various region was in the next phase. I believe I saw 25% occupancy for dine-in operations at a restaurant, which again, we're not there yet. But that is, given that we're talking about the posture of this case and what the next steps are, it does sound like there are current restrictions are being extended, and that there is some reason to believe in the somewhat near term that those might be lessened, but that depends on how various features and metrics transpire and removed. Anything else you'd like to add, Mr. Selsky? Thank you.
Judge, court reporter is asking something.
I'm sorry, I can hear that.
Well, your audio is going in and out, and Nyla, your audio going in and out and something like that.
Okay, thank you. I'll repeat myself. So we currently have the current restrictions for some additional number of weeks, and we may have some letting of those restrictions, it sounds like, based on how various metrics are measured in the coming weeks. We are not there yet. And again, that is something that the court is just generally taking judicial notice of the posture of the landscape of these regulations, unless someone has an objection to that. I don't see anyone making a motion to object to that. Just so that I'm fully informed as to the backdrop of the legal issues that we're facing with these pieces right now. So, Mr. Slusky, I believe you indicated that you were done with your comments. Is that correct? And he's nodding. Thank you. Mr. Dew, I'll move you. It's your motion. You get the last word.
Thank you, Your Honor. I would again just point out that Spiffy has not presented any evidence to the contrary to the department's submissions, and there is ample basis in our submissions to show the irreparable harm and the need for the TRO to continue, and we would ask for that relief. Thank you.
Thank you. The court is prepared to rule at this time. As I noted, that this comes before the court on a show cause hearing to determine whether or not the temporary restraining order that's already in effect should continue in full force and effect until further proceedings in this case, specifically a hearing on a preliminary injunction at some point in the near future. In response to the state's request for this continued order, I want to make it clear what is and what is not an issue in this case. Again, as I said at the outset, but it bears repeating, the only matter that is governed by my order is the physical geographic location of where a customer consumes food after ordering and receiving it from Spiffy's. No one at this point is ordering Spiffy's to close or to food to customers, or that customers can't come in and get that food. The only thing that my order governs is the physical geographic location of where that food is then consumed. There are other legal matters that are not at issue in this hearing today. There has not been any challenge to the constitutionality of the pieces of the statutory framework that permit a governor to issue decrees as has been issued in this case. Nor has there been a challenge to the constitutionality of the actions the governor has engaged in pursuant to that legislative authority. In fact, the Constitution has not been referenced in these hearings or these pleadings whatsoever. We are, as a result, starting with a framework of the assumption that these actions by the governor are valid because they have not been challenged in these proceedings. So specifically, the issues that have been raised by the defendant in this case are a couple. First, there's a reference to waivers being signed and filed by various employees at Spiffy's. There is no recitation to any law, however, that would permit a worker to waive the protections of the workplace safety laws of the state of Washington, nor do I believe that there is such authorization under the law. Perhaps that's why that law was not cited. Additionally, there is reference to the fact that Spiffy's is engaged in various other safety protocol that would allow them to operate safely. However, the executive action engaged in by the governor lays out certain things that need to be done or need to not be done. It is not within the discretion of various entities governed by those decrees to determine if there's an alternative path that they would prefer, that they think would work better and allow them to continue the operations that they want to continue. The law is the law, and it has not been challenged in this case. And the law dictates, under these circumstances, that indoor dining not occur. And that there is not some alternative path that Spiffy's or any other restaurant or establishment may pursue under the law to obviate the need to follow other portions of the law. Lastly, there's a reference to other locations such as airplanes or McDonald's or other establishments, and an argument that their locations are less safe than Spiffy's location is. However, those other establishments are not before me in this case. What is before me in this case is Spiffy's. I'll also note that there's no evidence in this record that establishes what is or is not the enforcement scheme of the Department of Labor Industries or the state of Washington at this time. And that bears noting, as a judge, actually as a citizen, I have, of course, following the news with close interest about what's happening with the COVID pandemic. I receive various pieces of information and have my own opinions about various issues. However, it is my responsibility under the Constitution as a Superior Court judge to decide cases based solely on the facts and records before me. In this case, what I have before me is voluminous affidavits filed by the state supporting their proposition that it is dangerous to have indoor dining occurring at the current time within a restaurant. In opposition to that, there is in effect nothing. There has been no affidavits filed countering those points. We have various declarations that have been filed requesting waivers or the belief that certain protocols are safer. But there is no one with any sort of expert's pedigree that might qualify as an expert witness, nor is there any science that's really being offered to counter the state's, in effect, uncontroverted and unchallenged position in this case. In effect, what I need to decide on the current motion is whether or not under the law, the statutory provision that allows these orders, when there is a workplace condition that presents a substantial probability that death or serious physical harm could result to any employee. Again, as I noted, as a Superior Court judge, I must decide cases based on the facts and the record that are properly before me in a given case. On one side, we have voluminous documents, facts, record, and affidavits that support the state's proposition that indoor dining does present a unique risk in the current environment. On the other side, we have, in effect, nothing to controvert that. And thus, I am going to be granting the state's request. I will be continuing the current order in full force and effect until another hearing occurs. I'm going to propose to the parties the 19th of January at 3 p.m. I also will note that in this case, at this posture, the constitutionality and legal validity of any action taken by the governor or the Department of Labor and Industries has not been challenged. Solely in this case, the challenge by the defendant has been as to the comparison of other locations and how they have been treated. The concept that what they have done is good enough, and a conclusory allegation that the standard hasn't been met. We don't have any facts, evidence, or law, however, that support any of those positions, either being true in fact or being sufficient under the law to defeat the state's request in this case. And thus, until further order of the court, and specifically we'll have a hearing on January 19th at 3 p.m., Spiffies will continue to be directed to not provide any indoor dining at their facility. Again, they can be open for business. They can employ individuals to prepare food. They simply cannot permit their customers to stay inside their building to then consume that food. That is the prior order of the court. That is the continued order of the court. And that is my ruling today. So I will touch base with now each of the attorneys and unmute them in turn. First, Mr. Dew, to ask if there are any questions or whether or not there are any issues with the January 19th, 3 p.m. setting for the next hearing. Mr. Dew?
No questions. Thank you, Your Honor.
Thank you. Mr. Selsky?
No, Your Honor.
Okay, thank you, everyone. I anticipate that Mr. Dew will be in a position as the prevailing party to generate an order that reflects my ruling and can present it to the ordinary means for my signature in short order. That's going to conclude this hearing today. Thank you, everyone, for your participation. The court is in recess.